open. So, I'm thinking, oh, that's what. Oh,
9:30 meeting. I see you. It's going to back to start.
I'm about to take it out the plug.
That's the green card. Mitsubishi. Well, yeah. You got a ticket. And leave it here. Yeah, I might go home. I don't have to go to Froggy's. Your car's going to Froggy's. Car ain't going to Froggy's.
Oh, what you gonna do? Stop there and wait, or did you get around sooner?
I'm confused. I don't know what you're saying. You're going to Froggy with your car. About your car. Take your car on out there and do what you have to do. You have to leave it. You have to leave it.
I'm back.
You can.
Updating their organization.
Right. It's just so- Yeah.
Let me go in here.
I'm really glad you
The
walked
last
up.
time and one of these damn things, you heard me tell the girl, hey, oh, you rolling your eyes and shit. I don't got time. I got time to be rolling these goddamn eyes with my damn
Doctors are
last
in.
month.
But
I wasn't going in person, but I decided I'm gonna stay here. I might have to take a number 4. So if you're looking for me, I might be taking number 4.
No. I was waiting on, that's why I got some milk. Waiting on some, items to come back this morning. We'll make sure.
I ain't campaigning for nobody. Nope.
I'll see you later, okay? Thank you.
Hey. Don't close doors. Can you hear me, Pat?
Yeah, I can. Yes, loud and clear.
Whatever. No, it's whatever. Yeah, right. Yeah.
What's up, sir?
Right.
You there, Pat?
I can. Yes.
Huh?
Yes.
Okay, I can barely hear him.
Hmm.
Oop.
Or already asked all the questions asked. But just think like, one, period of walking. Hospitalized.
Matter of fact, I was in the process of modeling this.
Mr. Bradley, could you please mute your mic?
Beg your pardon?
I need you to mute your mic.
Mute it? Okay.
Yes.
Hold on.
Thank you.
Go ahead.
So how loud they go up?
Good morning, everyone. Happy Wednesday. Please mute your mic until your docket number is called. Once you hear your docket number called, you will hear a brief description of what the notice of violations are. Then you are asked to raise your right hand to be sworn in. Okay. Mr. Chairman, we can go ahead with the preamble.
In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1796, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conduct their meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record before the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile versions and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also use the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located at the bottom of the WebEx screen. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comments on a particular matter. Mr. Jacobson.
Thank you, Mr. Chairman. This is Dan Jacobson from the Law Department. Preliminary issues, the live stream. Can we verify that the live stream is on and functioning?
It is.
Thank you. And Mr. Chairman, as the Law Department has done since these public meetings have gone virtual and or hybrid, law states its objection to the use of the chat function. Thank you.
Thank you. Ms. Davis.
Mr. Bradley,
Yeah, here?
Mr. Dink,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Mr. Gallagher, if you could give the 3-member advisory, please.
Okay, we only have 3 board members, which means that if our decision is not unanimous, which it usually is, then your appeal goes back to the city. If for that reason you prefer not to have your case heard, then let me know when we call your case that you would like to reschedule your case. Thank you. Well, first case is docket A 412-23, 3808 East 153rd Street.
Application and fees are in order. Notice of violation is condemnation of the main structure and the garage. Issued on December 20th of 2023. Appeal was received on December 28th of 2023, requesting for 6 months to complete abatement of the violations. Mr. Chairman, we originally heard this docket. It was scheduled on May 22nd of 2024, and it had to be rescheduled. If the appellant or his or her attorney and or representative, please state your name for the record. You're gonna come to the table and you're gonna hit the button in front to turn the mic on.
Colin Boone.
Mr. Boone, solemnly swear to tell the truth, the whole truth, so help you God.
So help me.
Okay, thank you. Go ahead and let us know what the plans are.
Okay, the plans are to get the house restored. The person that named the house never been in the house. So I sent them an email, get them to come back out because Miss Davis, I believe her name is Miss Davis, they was telling me that the part of the house that caught fire is just one bedroom. And that he could, instead of condemning the whole house, he could just say that it was this bedroom that need redone. So as you can see, the back part of the wall right there, that's the bedroom that caught fire. The rest of the house is just wall damage where they went in, fire department went in, holes in the wall to make sure it wasn't any more fire going through the house. It's a 4-bedroom house. Yeah, 4 bedrooms, and the bedroom is the one that caught fire. So I think Jay Vork, his name is, his email is Jay DeVork or something like that. I sent him an email. I asked him, I told him what time I'll be off work. I said I'd like to meet with you back at the house. Gave him my number. He never gets back in contact with me. Like chasing this guy, I'm chasing this guy to get my house uncondemned because the structure is not caved in. It's not. It doesn't even have a garage. I have pictures from inside the house when there was a fire. It's a brand new shed back there. The garage been torn down. So he's never been in the house, never been to the house. He condemned my house. I have the money to get the house back together, but when the house caught on fire, I had to rent the house for 2 years. 2 years is up in September. So my plans is to get the house back together so I can move back in it. I have some money, but I didn't want to start too early because people keep breaking in the house. Even after, every time they see me go to it, they'll try to break in the house, thinking there's something in there to get. So I was just, I want to put a house back together, spend all that money on it, and then somebody break in and tear it up because I can't move in because I end up violating my contract with the homeowner who I'm renting the house from.
Okay,
Now currently.
I want to ask you, how many rooms were upstairs?
And a bathroom.
There was a bathroom in 1 bedroom or 2?
No, it's 3 bedrooms upstairs and a bathroom.
Okay, and what about, you mentioned something about the garage?
I have photos. I was inside the room that caught fire and I was taking a picture, and it's not a garage back there. It's
A shed, you mentioned?
it's a shed, brand new shed.
Okay,
Like, so I'm not understanding. And like, they took them pictures. They didn't take a picture of the shed. The shed is right there in the driveway. So if he went back to take them pictures to condemn the house, and if it was a garage back there, he would have took the picture of the garage too. But he
okay.
didn't.
How much time do you think you need to abate the violation?
I just need to September. So it can warm up and get people, because my brother-in-law, he has a restoration house. Get guys in there, get it all cleaned out, back together. I have the money available.
Okay,
You know, just can't break my lease with this house, or I end up having to pay them because I had to rent it for 2 years.
okay, nobody's in the house now, right?
No, it's boarded up. I go by, check on it, once a week, because I stay like right around the corner from it. I'm a neighbor, check on it too.
Let's go over to Mr. Vanover. Mr.
This is Glenn Murray, acting Assistant Building Official for Mr. Vanover today.
Okay.
Mr. Chairman, the building department has takes no exception to 6 months. However, we would ask that permits be pulled as soon as possible to initiate the process.
Okay. All right, so, how long do you think it'd take you to pull the permits? We'd like to get them done within 2 weeks. Can you do that?
Okay,
All right.
yeah, I can have a problem, I don't have a problem. I'm trying to figure out, they keep saying, because he condemned the house, they said I have to go and get your spectral drawing done. Now, for me to do that, that's like $2,000.
Mr. Chairman, to the applicant, in this case, we ask for an architectural drawing only because we want it to be of a certain quality. However, if you're a good draftsperson and you can get us the information, or somebody who's a good draftsperson, and you fill out our forms, the rehabilitation form, you wouldn't need to have a design professional to do that for
Where
you.
would I get that?
Can you do that?
I mean, I try.
So that'll save you some money on that end. So we're gonna make a motion for February 26, 2 weeks, 2025, to obtain your permits, and August 14th, 2025, which is six months to abate the violations. Motion?
So move.
Second. Okay, moved by Mr. Bradley, second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out to you within 2 weeks. Thank you.
Okay. 505, thank you.
Okay, next docket.
You know, a draftsman or somebody who took drafting in high school,
Nah, I don't, to be honest.
I would.
What I'm saying is, do I have to get the whole house drafted or just?
I'm sorry, Mr. Chairman, we're ready.
Okay, next docket, A 171-24, 2653 Northmoreland.
Application and fees are in order. Notice of violation is elevator. Issued on August 27th of 2024. Appeal was received on September 26th of 2024, requesting for 6 months to complete abatement of the violation. Present for today's hearing, Assistant Chief Building Official Glenn Murray, Dan Jacobson, Law, Russ Gates, Law. Will the appellant or his or her attorney and/or representative please state your name for the record?
Good morning. This is Robert Friedman. I'm the attorney on behalf of the appellant.
Okay, Mr. Friedman, solemnly swear to tell the truth, the whole truth, so help you God.
Yes, I do.
Okay, go ahead and proceed.
Thank you, Mr. Chairman. This VN notice involves the elevators at 2653 North Moreland Boulevard. That property is owned by an entity by the name of Hats 2 LLC. However, the violation notice was issued to Joe Bobeck of Guardian Management Company, and this appeal was filed on his behalf. Mr. Bobeck is the principal officer of Guardian Management Company, and for a period of time was retained for the purpose of attempting to manage this property and bring the code issues into compliance. During the period where this appeal was pending, they were removed as the managing agent. They do not have the authority or the wherewithal to conduct any code violation abatement, and I don't believe that Mr. Bobeck is properly named as a respondent to this violation notice. The elevators are and have always been the responsibility of Hats 2 LLC. Unfortunately, there's a pending foreclosure in federal court that was filed against Hats 2 LLC. The appointment of a receiver has been sought by the federal at the federal court, and there's an evidentiary hearing to determine whether or not a receiver is put into place. I think the 28th of this month. What I can represent to you from my communications with the owner is that this property is currently not occupied by any residents, so that the inability or the unavailability of the elevator certificate is not an imminent issue of health or safety.
Mr.
Okay.
Chairman, this is Patty, if I may, Mr. Chairman, to
Yeah.
Appellant's Counsel. When was your client, Mr. Bobeck, removed as managing agent or the Guardian Management Company?
I don't.
When were they?
I don't have the answer to that question, ma'am, but I do know that it was in 2024.
At the time you filed your, actually it's Mr. Owen, but I presume he's from the same office. That, Mr. Chairman, to Appellant's Counsel, at the time the filing of the appeal docket and your letter on September 23rd, 2024, had they been removed?
They were still involved in the management at that point, but they were not directly responsible for the maintenance of the elevators.
Thank you, Mr. Chairman. He's testified that at the time they filed the appeal, he was still, he and the entity were still the entity management for the property, but at some point they were removed. So that would be the board's discretion. I don't know what the city's arguments will be. I just wanted to clarify that. Thank you.
Properly issued is what you're saying.
Well, I'm saying that he's arguing an objection to the violation notice for the city to argue against his objection. But at the time of the filing of the appeal and the appeal statement, counsel has indicated that they were still in place as the manager of the property.
Okay.
I think that pertains to Guardian. Mr. Bobeck individually never accepted, was responsible for the elevator.
That's your argument to the board. That's your argument to the board. They understand that. However, they're both named. They're both named on the violation notice. It's just his name is on top.
I understand that that's my argument, and I'm trying to make it. What I wanted the board to know is that Mr. Bobeck is not the local agent in charge for this property. He has not agreed or signed on to maintain responsibility for these elevators. And again, these elevators were always the responsibility of the owners. So I would ask that to the extent that a violation notice is appropriate, it would be appropriately issued upon the owners, not the individual member of the former management company. I don't think that's reasonable.
Mr. Friedman, are you making that same argument as to the entity or just to Mr. Bobek? So the board is clear.
I'm making the argument as relates to both, but it looks to me, and it's hard to tell from the VN notice who this is directed to. The first name on the line is Joe Bobek. So I can only construe that as the city alleging that Mr. Bobek in his individual capacity is responsible. But it's not clear from the document from the VN who they're seeking to have held responsible. My position is that it's not either of Mr. Bobek or Guardian Management Company, but certainly Mr. Bobek, who is named, would not be responsible for the elevators in this instance.
So, Mr. Chairman, to be clear, he's making it as to both the named individual as well as the named entity who at the time of the filing was the property manager entity over the property. Thank you.
Okay. This is going to court, is that correct?
I presume you'd want to hear from the city as to both the violations and as to Mr. Friedman's arguments.
Sounds good. Okay, Mr. Murray.
Mr. Chairman, what I'm hearing is originally they asked for 6 months to complete the abatements. And now I'm hearing that there's not any party who will be completing the abatements. So and now the building is on top of everything else, a vacant building. I recommend that the board remand to the city.
Okay. Yeah, and then they can clear this up. They can still do whatever they have to do. So a motion is in order to deny more time, remand the property division of building and housing for any further action. Motion?
So moved.
Okay, moved by Mr. Denk. Mr. Bradley, I gotta have you unmute. Mr. Bradley? I need you to unmute. You have to unmute. Mr. Bradley, unmute your device. I think he's working on it. Mr. Bradley, can you give me a thumbs up or a thumbs down as to the motion? Thumbs up. Okay. All right. Go ahead and call the roll, Ms. Davis.
Mr. Chairman, you have to have the motion and then seconded, and then you have to call the roll. Are you making the motion on behalf and then seconding through Mr. Dank? Because that hasn't happened.
Yeah, that has happened. We made the motion and through Mr. Dank, and then Mr. Bradley has agreed. The motion is in order to deny for time, remand the property division of building and housing for any further action.
Mr. Bradley?
He gave a thumbs up.
Okay. Mr. Dink?
Yes.
Mr. Gallagher?
Yes.
Objection.
What's your objection, sir?
I've heard 2 yeses.
2 yeses. There's 3 of us. We got
I
one
didn't hear
thumbs.
the third.
Oh, we got one thumbs up. He's having trouble unmuting his microphone, and we have the both of us agreeing, and so it's good for the 3 of us. I'm accepting that.
So, Mr. Chairman, are you overruling his objection?
Yes.
Thank you.
Okay. Notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket is A 172-24 2880 South Moreland Boulevard.
Application and fees are in order.
Mr. Chairman, can we have a discussion on the previous docket?
No, they've closed. It's been closed. They've moved on. That's supposed to be done at the time.
Application and fees are in order. Notice of violation is elevator issued on August 26th of 2024. Appeal was received on September 23rd of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Assistant Chief Official Lynn Murray, Dan Jacobson Law, and Russ Gates Law. With the appellant or his or her attorney and or representative, please state your name for the record.
Mr. Chairman, this is Robert Friedman again, Powers Friedman Lynn, on behalf of the respondent. appellant.
Okay. Solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, very good. Go ahead and proceed.
Mr. Chairman, this is a similar appeal. The VN notice identified Mr. Bobeck again and Guardian Management Company with respect to the VN requirements. We believe that the naming of that individual and that management company are inappropriate. I mentioned in my previous comments that Mr. Bobeck and his company were removed as the managing agent for this owner, Cleveland 2 LLC. Cleveland 2 LLC is a different separate LLC, but affiliate entity of the previous one that we discussed, HATS 2 LLC. Also the subject of a federal court foreclosure action. Nevertheless, during the interim period, this owner did bring the elevators into compliance and has obtained an elevator certificate, which I believe I can share on the screen.
No, you cannot share your screen, unfortunately. Whatever that you wanted to submit to the board for review was due last Friday to be put into today's presentation.
Well, for the purposes of testimony, file number 2777 from the City of Cleveland Department of Building and Housing Division of Code Enforcement certifies that that elevator that was the subject of the VN does have a certificate of elevator operation.
So you have complied.
Yes.
Okay. Let's go to Mr. Murray.
Mr. Chairman, we're not finding that in the Acela system at this time. And I didn't see it when I did my research, but we will say subject to our finding this. Mr. Chairman, to the appellant, is this building vacant also?
There is. I'd like to be able to answer that question accurately. Of the 3 buildings, there are only 2 tenants total within these properties, and I know that either 2870 or 2880 has occupancy, but not the other 2. So I'm not in a position to answer your question directly.
Mr. Chairman, this is Patty. If the appellant could forward to the board and the building department the certificate of compliance that he's received that before this is adopted, whatever you end up doing with it. That way the board would have it based upon the testimony as well as the department.
You can do that within 2 weeks, right, sir?
I can. Will I send that to Ms. Davis?
Yes.
That is correct.
Mr. Chairman,
Yes.
may I ask, this is Russ Gates, attorney for the City of Cleveland. May I ask a question of the appellant?
Yes.
Just to clarify what you had stated, so I can understand, you said that you believe there's 2 tenants across the 3 properties. Is that accurate?
That is accurate, and I know that none of those tenants are in 2653 Northmoreland. That property is vacant.
Okay, thank you very much.
You're welcome.
Mr. Chairman, to the appellant, the building department would ask that you file the paperwork to have these buildings added to the vacant building registry.
All right. I will have to be separately retained, but I believe the owners will retain me to go ahead and do that.
Okay, and once again, that happens, you can do that within the 2 weeks?
Yes, sir.
Okay, very good. So, let's see. For this one, we're, I don't know that we actually need a date on this. Ms. Davis? I mean,
Mr. Chairman, I would recommend you give a date through today because the
Okay.
testimony is he has the paperwork which he's going to provide. Thank you.
Okay, sounds good. So, let's see. A motion is in order, to grant till today, which is, February 12th, 2025 to, abate the violation.
Move.
Moved by, Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket is building docket A 173-24, 2870 South Moreland Boulevard.
Application and fees are in order. Notice of violation is elevator. Issued on August 26th of 2024. Appeal was received on September 23rd of 2024, requesting for 6 months to complete abatement of the violation. Present for today's hearing, Assistant Chief Official, Building Official Glenn Murray, Dan Jacobson Law, Russ Gates Law. Would the appellant or his or her attorney and or representative please state your name for the record?
Yes, Mr. Chairman, Robert Friedman, law firm Powers Friedman Lynn, on behalf of the appellant.
Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, go ahead and proceed.
Thank you. This is another appeal on behalf of the named parties in the violation notice, Joseph Boback and Guardian Management Company. Again, they managed the property on behalf of the owner throughout 2023. In 2024, they were removed, and I mentioned in my previous presentation, at some point in 2024, that what they were doing for this property was essentially maintenance and labor support at the request of the owners. They are not responsible for the maintenance and repair of the elevators at this property. Nevertheless, I've received information from the ownership group Cleveland 2 LLC that this elevator is in compliance and has received a certificate, file number 2733, a certificate of elevator operation for the certification year 2024. And for that reason, I believe that my appeal should be granted. Again, this is a building that I think only has 2 tenants, but the elevator has been certified, and the property and this business entity are under foreclosure. A determination as to whether a receiver will be appointed to operate this property and divest this ownership group of control, I believe the 28th of this month. So the management and control of this property, like the other 2 that I mentioned, are most certainly the subject of some dispute at this point.
Okay, Mr. Murray.
Mr. Chairman, if in fact that is the case, that there is a current elevator certificate that we were not aware of, we would ask that it be forwarded to us for our research. Otherwise, I would ask you to remand to the city.
Okay, and do you need anything else on the building? You're not requesting anything?
I'm sorry.
Okay.
So again, it should be added to the vacant property registry if that's the case. We're finding in our records that although inspections have happened. We're not seeing that a permit, that the final certificate has been issued. However, we will await the documentation from the appellant.
Mr. Chairman, this is Patty. Same as the last one. If he could send that both to Ms. Davis and the department, similar to that. And then you could presume it would be that there would be no objection to the same compliance date through today, since the testimony is that it's in compliance. Thank you.
Mr. Chairman, Dan Jacobson from Law, through the chairman to the appellant's representative, if possible, if there was no inspection done, or if the city needed assistance in gaining entrance to the building in order to inspect, would you have information on somebody, a contact person, to allow the city entrance into the building?
I don't want to misrepresent that, sir. What I can tell you is, this is a very difficult situation. The ownership group went into foreclosure. The principal member of that ownership group is now deceased, and that is a very recent development. Mr. Steiner, who was the principal of these business entities, passed away earlier this month, and we've been communicating with a variety of people. My expectation is within the next 2 weeks, a receiver will be appointed, and that will be the person who will be determining whether or not they would be willing to provide access and to what extent. So I'm sort of waiting to take a directive from the next person who is put in charge of this property.
Well, I believe that as a part of the motion that the city needs to be able to, when that happens, to be able to have access to check the elevator. So that will be a part of the motion when that happens, when that occurs.
Sure.
Mr. Chairman, Mr. Chairman, to the appellant, you said an umbrella or a group of owners. Could you clarify that? Because I noticed you were here for Cleveland 2 LLC and Hats 2 LLC.
That is correct. Cleveland 2 LLC and, well, Hats 2 LLC is the ownership entity for 2653 Northmoreland, and Cleveland 2 is the ownership group for both 2870 and 2880 Southmoreland. However, all of those properties are named, I should say both of those business entities are named defendants in the foreclosure action. So the action by the bank is to foreclose on all three of those properties owned by both business entities.
Mr. Chairman, this is Patty. The testimony has been provided that it's in compliance and that he was going to provide that information to both the board and the city. If we could move this along.
We can. Motion is in order for February 12th, 2025, to abate the violation and to get the information back to Ms. Davis. Motion. Moved by Mr. Bradley.
Second.
Second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Next docket is building docket A 177-24, 6311 St. Clair Avenue.
I just want to note that is a typo on the slide with the owner's name and information. Actually, this is the owner information is Wall Street Nottingham Development. The notice of violation is a condemnation of the main structure issued October 10th of 2016. Appeal was received on September 9th of 2024. The appellant did not state how much time they needed to complete abatement of the violations. Present for today's hearing Assistant Chief Building Official Glenn Murray, Dan Jacobson Law, Russ Gates Law. Will the applicant or his or her attorney and or representative please state your name for the record? You're muted, Mr. Miller.
Eugene Miller, can you hear me?
Yes. Mr. Miller solemnly swear to tell the truth, the whole truth, so help you God.
Yes.
Okay, go ahead and proceed.
Good morning, everyone. Thank you for hearing this case today. The Executive Secretary, the board members. In 2024, I had a contract next door to this building, cutting the grass. And I was cutting the grass with one of the local development corporation. And I was like, wow, this is an interesting layout. What our development company, our nonprofit can use. We're into farming. So I looked into it and it owed $63,000 in back taxes. I said, wow. So I did the research. The building was, it has taxes on it. So I contacted Calvert County Land Bank. And at that time, unfortunately, the executive director has now passed. So I spoke to him at that time, dealing with the current councilman, Anthony Harrison. They was telling me about how long this property's been vacant. I had to go through all these steps to show them that I can get it done, how important it is to the community to have this nuisance abated. And it took maybe 3 months, going, and unfortunately, and then the day I received the building, I believe I received the building on August the 10th. That's the same day that the director of the land bank passed away. And so when I received this, I got the information, I'm ready to go to work. And I find out it has combinations on it. And I know that you have buyer beware. So through that process, I did not know it was anything other than the back taxes and the building needs work. I didn't know that it was vacant. Now I know anything you look into buying, regardless, you need to do your research. So immediately I reached out to, I was told to reach out to the board of building and standards, and they explained me the process because I have never been on this side of the table. So on that day, I believe it was back in August of 24, I got information together, did the research, and I put my information in, and now we're here today. My plan, because I'm learning what this information means as being the chairman of the board. So our goal is, because I see it's like 20 different issues. Our goal is to keep the brick, the front part, and tear down the rear. We want to install a greenhouse in the back because our whole mission is to help with food deserts. So if you look at the building where it has the brick, everything in the rear is going to be demoed. We've got estimates on the demo. It looks to be about estimated $20,000 to have the rear demoed. We worked on, I believe, a site plan. We're working on receiving funding for one of the Cleveland City Council members. We have an application on file. That process takes a while. So in the meantime, what I've been doing is learning the process with government to understand what's going on. And so I'm going to be redundant. Our goal is to rehab the brick. Now, if in this spring, when the contractor get out there, and he says, "Look, Mr. Miller, we like your plan about demoing the rear." If they go in there and they say, "Well, we can't," I think you can rehab brick. So I'm optimistic about the brick. So, but if they say, "Mr. Miller, you're better off just tearing everything down," then that's what I would do. That's why I didn't put a time on there, but I would ask for at least 12 months to be able to solve this plan. But the rear will be torn down regardless of, the rear will be torn down within 12 months because to move forward, we can't have the rear there. The building's been secured. Far as no one's been in there since we obtained it back in August of 24. We'll make sure the grass is cut and make sure there's no other kind of things. Also this summer, we're going to be taking those boards down and trying to make sure we beautify it so it won't be a nuisance to the community with that graffiti on there, and make sure it won't be a nuisance to the community to keep the grass cut and to make that eyesore look better.
Okay, I'm going to stop you there for a moment. And you're gonna change kind of the use here. And I'm not sure about like leaving the front and then doing what you're gonna do to the back. But it could actually possibly come into a zoning issue. I'm not sure. So I'm gonna go over to Mr. Murray and have him talk about this.
Mr. Chairman, the building department would like to see the building fixed and would not have an objection to an extension. However, we want a date certain for permits pulled.
Okay, well, we generally speaking, we don't give a year on something like this. We would go with 6 months and that you would pull some permits within 2 weeks as to whatever plan it is you're going to do, whether you're going to demo the whole property or you're going to rehab whatever portion of it is. So we can give you that time. We can give you 6 months to work on that. So we would like to see you pull some, I don't know, this is something I'm not sure if he would need more time on the permitting, Mr. Dank, because you may need some drawings.
What I'm thinking, Mr. Chairman, is allow some amount of time for the permit, and to your point, maybe more than the 2 weeks, maybe 6 weeks, and then let the permitting process take over and not have a end date for the completion of the project.
Okay, I see, Mr. Miller. Yeah, your hand is up.
I just want to understand because I'm learning the terminology because, for example, I did the research and I understand what you're saying about zoning. I'll look into the zoning because it's zone retail and all we want to be able to do is to use it as a farming production indoors because it's hard in the wintertime in the city of Cleveland to grow anything. But now the back part, if I'm not getting it because of funding, if I'm not getting it demoed in the next 4 months, do I need to pull a demo permit to be able I mean, I got the estimate cost is about $20,000 to tear it down. But would I pull a permit to 2 weeks from now, knowing I'm not going to get it demoed until I receive the funding? And then the brick part, far as I've only been in this building one time, and that was the day that we received it, August, and we went in to make sure nobody goes in there. I haven't been back in there. So I understand. I'll go find a contractor and let him or her go in there and say, Mr. Miller, this is what you should do. If the contractor come back and say, Mr. Miller, I would demo the whole building.
Mr. Chairman, this is Patty, if I may. So the buyer beware, caveat emptor, whether or not he's in the property or the entity, because this is owned by an entity, it's going to require permits, plans and permits, as the board and Mr. Murray has indicated. But how that plan is structured, what dates are presented to the city, that's wholly within the realm of the appellant's choice. The appellant has to do that. No one here can guide him. It would be unethical and improper for anyone to craft any information for him and plan. He most certainly can reach out to the zoning administrator, to the city planning department, to the planner of the area, to the council person, to the CDC. There are a wealth of available resources, but it is incumbent upon the entity appellant, who I presume is Mr. Miller, is it for this entity, but it is not. He's presumed to know the law. The law says you're presumed to know the law. So he has to do that. The board can grant or deny the time, can grant or deny what it feels it decides is appropriate in this instance, but the appellant has to go forward and do this. Thank you.
Okay, so what we're going to do is I'm going to take Mr. Dank's suggestion that we go with 6 weeks. This gives you time to decide what you're going to do. So March 26th, 6 weeks, 2025, to get your permits as to whatever you're going to do. Motion?
So moved.
Moved by Mr. Dank. Mr. Bradley? Mr. Bradley?
Second.
Okay, very good. Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice to be sent out within 2 weeks. Thank you. Good luck.
I have a question. Okay.
Next docket is housing docket A 174-244088 East 72nd Street.
I've been on it today, but they didn't have a quorum.
Application and fees are in order. Notice of violation is condemnation of the main structure and garage issued on June 25th of 2024. Appeal was received September 26th of 2024, requesting 6 months to complete abatement of the violation. Present for today's hearing, Assistant Chief Billing Official Glenn Murray, Dan Jacobson Law, Russ Gates Law. Would the applicant or his or her attorney and or representative please state your name for the record?
Robert Levine with Haas Real Estate Holdings LLC.
Okay, Mr. Levine, I solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay.
Mr. Chairman, just so
yeah.
you know, Mr. Brancatelli is also in room 514 on this matter as well. If you could swear him in.
Okay, Mr. Brancatelli, solemnly swear to tell the truth, the whole truth, so help you God.
You have to press the button in front.
I do.
Okay, very good. Okay, go ahead, Mr. Levine. Let us know what your plans are.
So this property was purchased in a group of 22 homes on a receivership auction, and we were unaware that it was condemned. When we learned that it was condemned, we immediately called the demolition department to see where it stood, and then we filed for the appeal as well as pulled a general permit or applied for a general permit. I had also met with the CDC a couple days ago on Monday, and we have a whole plan developed with deadlines as far as when we're going to do the permits, the HVAC, the plumbing, and everything. And that those documents were submitted to the CDC yesterday.
Okay. Mr. Brancatelli, you want to speak now or wait till we hear from Mr. Murray?
I prefer to speak first. Thank you.
Okay, go ahead.
Thank you. Thank you very much. And I just want to double check, if I can, with the secretary, if she received the correspondence from Southwick Village Development.
Through the chair to Mr. Brancatelli, the board is in receipt. However, we did not receive permission from the owners for you to speak on their behalf today. So that was something that needs to be submitted from the owners to the board for a CDC to speak on behalf of them.
Okay. I think the CDC was just speaking on behalf of the CDC, not on behalf of the owners. But either way, if I can, just first my specific interest on this is we have dealt with receivership properties previously, and what the meaning of people who purchase receivership properties. This property specifically is just around the corner from me, and there are a number of properties that they purchased. One in particular in Ottawa, which is just a few doors down from where I live. They purchased a couple hundred properties at the end of last year. The meeting with the CDC was pretty clear that the expectation is that properly pull permits for the work being done. The good news is that when the CDC met with them, they talked about keeping property secure. My interest East 72nd and the following one, Fullerton, were both OVV. When Southwick Village met with them, they are now secure, which is great news. I'm looking forward to a fruitful relationship with them. I would respectively submit the list of properties that they did purchase out of receivership. Some have been sold, but as mentioned earlier, if I can, here we go. Thank you. The receivership clearly states that properties must be adhere to city codes, and specifically what was noted in previous part of these hearings, that they must register vacant properties. The majority of these properties are vacant, so they must be registered. And then also the properties that are occupied must also have a rental registration as well. And the owners will informed that the properties that are condemned, that they have a responsibility to pull permits. And as Mr. Levine noted, that they did come to agreement with Southwick Rose that they will pull permits. My understanding is on commercial properties, permits must be pulled by a contractor. You can't pull homeowner permits. Once they secure those permits, and they'll be able to move forward with the work. And the CDC fully supports giving them additional time, provided they meet those benchmarks.
Mr. Chairman, this is Patty. As it relates to the list of properties, this board may certainly accept whatever evidence it deems relevant. What is before this board are these individual properties. However, as previously argued to the board, it may go into a relevant factor as to timing or as to when resources that are available to any person or entity for resources that are available for the rehab and in any crafting of any motion for timeline. Thank you.
Okay, thank you. Mr. Murray.
Mr. Chairman, the applicant has applied for a permit in this particular, for the repair of this property. Ultimately, the building department would have no objection to the 6 months that they're asking for. However, I would ask that the applicant reach out to their plans examiner to expedite whatever information he's looking for so he can complete and approve the permit application.
Okay, and what timeline do you think on that, Mr. Murray?
It was submitted 9/30/24, and it probably shouldn't have taken this long, so I'm guessing that we're waiting for some additional information. So, I mean, I would have him call SCP
Okay.
to try to figure out what it is that's holding up this approval. And then, Mr. Chairman, just to correct Mr. Brancatelli's statement, only the owner can only pull owner-occupied permit. So even if it's a residence, it would need to be a licensed professional contractor.
Okay, he's shaking his head. He
I
understands.
understand.
Okay.
Yes.
Okay, so,
Mr. Chairman, Dan Jacobson
Yes.
from Law, through the chairman to the appellant, did you submit information or can you testify of your authority to act on behalf of Haas Real Estate Holdings? We have documentation from a Jeff Haas, and I'm not seeing anything.
Yeah, I'm also a member of the LLC as well. So
Could you,
I have a corporate resolution as well that I could submit showing that I can act on behalf of the company.
good. We need you to do that.
Okay.
Okay. So you can contact Ms. Davis' office.
Yep.
So what we're looking at is that you're going to find out what the holdup is on the permitting and
When I went online and looked, it said that it was pending pending the appeal. That's what I thought that it said, but I'll call and find out.
okay.
Mr.
So,
Chairman, to the applicant, in general, that means that there was likely an adjudication written, and either you respond to the adjudication or you appeal the adjudication. So I'm guessing that there's just some communications between the applicant and the plans examiner to kind of get this off the top dead center.
Okay. Well, we can just move this to the end date and then they got to sort that out. So we're looking at August 14th, 6 months, 2025 to abate the violation. Motion
So move.
moved by Mr. Bradley,
Second.
second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket is housing docket A 175-24, 7116 Fullerton Avenue.
Application and fees are in order. Notice of violation is condemnation of the main structure in the garage, issued on July 23rd of 2024. Appeal was received on September 26th of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing, Assistant Chief Billing Official Glenn Murray, Dan Jacobson Law, Russ Gates Law. Will the applicant or his or her attorney and or representative please state your name for the record?
Robert Levine.
Okay, Mr. Levine, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what the plans are.
Same exact as the last case.
Okay,
Everything is the same. We applied for the permit as soon as we were aware of the situation. Once we closed on the property, we met with the CDC. We developed a timeline and we secured the property.
okay. All right, well, let's go over to Mr. Murray.
Mr. Chairman, I have an adjudication letter from, I'm sorry, Mr. Chairman, I have an adjudication letter from October 30th, 2024, approved by one of our plans examiners, outlining the additional information he needs on the drawings in order to be able to complete the approval of this project. I just want to make sure that the applicant is in receipt of this letter, and if he isn't, he needs to reach out to his plans examiner so that they know how to correct these drawings to get to an approval. That being said, the building department has no objection to 6 months to complete the violations, and it looks like they're in the process. It just looks like there's just has to be a little communication and some more plans submitted or some additional information submitted to get to an approval.
Mr. Levine, I think you were about to say something.
Yeah, no, I didn't receive it, but I will call the plan examiner immediately.
Okay, once again, we'll go to,
And Mr. Chairman,
Yes.
again, I would ask that the appellant's representative, Robert Levine, send in authorization to act on behalf of Haas Real Estate Holdings.
okay. Yeah.
So
you
you
heard
tell
him,
that to
Mr.
Ms.
Levine.
Davis?
Yes.
Yes.
We'll do that immediately.
Okay, motion is in order to grant till August 14th, 2025 to abate the violations. Motion,
So moved.
okay, Mr.
Second.
Bradley,
Second.
all right, Mr. Dank.
Mr.
Second.
Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes,
Mr. Chairman, give me 3 minutes, please.
I will. Okay, you'll be notified within 2 weeks. Thank you.
Thank you, everybody. Bye-bye.
Yeah. Hello?
Yeah, Howard, we're on a little bit of a break here. As soon as you hear Ms. Davis, then you'll know we're starting back up.
Okay.
Okay, Mr. Chairman.
Okay, housing docket A 176-24, 18125 Harvard Avenue.
Application fees are in order. Notice of violation is exterior maintenance. Issued on September 6th of 2024. Take your time. Applicant was requesting 6 months to complete abatement of the violations. Present for today's hearing, Assistant Chief Billing Official, Glenn Murray, Dan Jacobson, Law, Russ Gates, Law. Will the applicant or his or her attorney and or representative please state your name for the record? That would be you, Ms. Davis.
Linda Davis.
Okay, Ms. Davis, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, go ahead and proceed.
Basically, as you can see, that actually I was waiting on my insurance company. In the meanwhile, I couldn't find anybody to do it while I was waiting on the insurance company to put it up. So finally, the insurance company, because that was part of the wind and storm damage that damaged the whole house. And as you can see, they repaired the whole house, including that one piece of gutter.
So you are complete?
Yes.
Okay.
As you can see on that corner end where that one window is the part that the city violation came in. That's over the bit, that one window where that black thing is.
Okay. Mr. Murray.
Mr. Chairman, our inspectors have certified that this has been completed.
Okay, we'll give to today's date and we'll move on. Motion is in order to grant till February 12th, 2025 to abate the violation. Motion?
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out to you within 2 weeks. Thank you.
All right, thank you.
Give me 1 second, Mr. Chairman,
Okay.
while I assist her with getting out.
Okay.
Hey. Huh? Yeah. I'm still on there right now.
Okay, Mr. Chairman, we're ready for docket 178-24.
Okay, 17824, 1245 Norwood Road.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on September 4th of 2024. Appeal was received on September 24th of 2024, requesting for 1 year to complete abatement of the violations. Present for today's
Where'd you go?
hearing, Mr. Bradley.
Hello?
You got to mute your mic.
Okay. Sorry about that.
Okay. Present for today's hearing, Assistant Chief Billing Official Glenn Murray, Dan Jacobson Law, Russ Gates Law. Will the applicant or his or her assistant and or attorney please state your name for the record?
Michael Schellenberger.
Okay, Mr. Schellenberger, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, go ahead and let us know what the plans are.
Okay. This was, the violations were for exterior paint, repair on the porches, and a small repair on the gutter. With some difficulty, I was able to obtain I had trouble getting people to come out to look at it because the neighborhood is kind of dangerous. But I finally was able to get someone to do the painting, which is complete. And I have hard copy photographs here, if that's helpful. I missed the deadline because I didn't get the email in time.
Okay.
So the exterior required extensive scraping, caulking, priming, and finish coat, and that's been completed. And that's as far as we got before the weather turned bad. And I haven't been able to obtain anybody that willing to do the porch work until the weather breaks. So that work remains unfinished, but the paint, which is pretty much the major part of the eyesore of the property, is complete at this time. At the time that I made this appeal, I requested 1 year, which was certainly a lot of time. But at this point in the game, I think that 6 months from today would be sufficient to find people to do the work on the porches and the gutter. I'm unable to do the work myself due to health reasons, but we have made significant progress on this.
Okay, Mr. Murray.
Mr. Chairman, to the appellant, is this owner occupied?
No, this property is vacant right now. I was kind of forced out of there after 6 burglaries, 1 car theft, and my best friend getting shot 2 doors down from this. It's a bad street, and I had to get out.
Mr. Chairman, the building department has no objection to 6 months.
Okay, motion is in order to grant the appellant to August 14th, 2025 to abate the violation. Motion?
So moved.
Moved by Mr. Dank. Mr. Bradley, we got to have you on mute.
Second.
Okay, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you, Mr. Chairman. And hope for your improved health, Mr. Bradley.
Yes.
Okay. Does anyone need these to keep them on?
No.
You don't need a copy of it?
If you want to, are you going to leave them here?
Yeah, I'll leave them for Ms.
Okay, I'll put
Davis.
them in your file.
I missed the deadline on sending them electronically.
That's okay. Thank you.
Have a good day. Thank you, everyone.
Okay, are we ready for approval of resolutions?
We need to read that the next docket has been withdrawn, Mr.
I'm
Chairman.
sorry, you are absolutely correct. Okay, so the docket A 17924 14109 Milverton Road, it has been withdrawn. Okay, now the approval of resolutions, A 026-25, A 159-24, A 160-24, A 161-24, A 162-24 through A 170-24. Motion?
So moved.
Motion by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Approval of minutes, January 29, 2024. Are there any additions or corrections?
No.
Okay, motion.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Is there anything else to come before us?
No.
Okay, we are now adjourned.
2 weeks.
2 weeks.
Have a good one.
Bye.